Okay, I want to bring in Shanon Gray. Shanon Gray is representing the families, many actually, not just the Goncalves family, but also he's helping to represent some of the other families as well. And he's had an uphill battle in his work because the judge in the case at the county level decided to impose a gag order, and there is quite a robust effort to fight that gag order, not only on my part and my colleagues in the media, but Shanon, on your part as well. So can I start, though, with today and this sort of remarkable turn of events? I want to get your legal reaction to what you saw today, both a refusal to enter a plea and a request for, a speedy trial to begin October 2nd.
Well, I mean, procedurally, everything was in line with what he had the right to do. He could have took the stand in silence or plead not guilty or guilty. I think it was a surprise to everyone that he didn't technically enter a plea by saying not guilty. That being said, every right to follow that process. The trial setting that they put today, the likelihood of that going, I don't know. I don't think it's likely that we'll have a trial in October. That being said, it's within his speedy trial rights. And if he doesn't waive his speedy trial rights within that time frame, after that time frame, the judge can still extend it by finding good cause to extend the trial. So it's not completely up to Mr. Kohberger as far as when the trial is set. It can be extended by the judge if he finds good cause to extend the trial date, to extend his stay in custody. So
it's why it was so critical to talk to you today, because I am always curious about speedy trial. I understand the rights of the American citizen. I understand in our system of American jurisprudence, anybody who's in this country gets the protection and the benefit of our Constitution. Tell me a little bit more about this extension. Are we talking the judge? It's within the judge's purview to find cause for extending a month, 2 months, a year? Or what is speedy trial really if the judge steps in?
Mind you, the state would, if the defense doesn't want to waive the speedy trial, the state would have to ask for it in some way. They would have to give a basis for it. And the judge could either extend, they might ask for 2 weeks, or they might ask for a month or 6 months. And they might ask for 6 months and only get 3 months. It's really up to the judge to determine what is fair, because obviously you always want to have a fairness for the defense counsel and the defendant in the case that's being charged, but there's a level of fairness in the state's case. Let's say there's some unavailability issues that come up with some critical witnesses in the state's case. Then they could always ask for a reset, and the judge could possibly and most likely would find good cause if that was the case, because it would compromise the state's case in some way if they didn't have their critical witnesses there, maybe a lead investigator or the coroner, or there's all kinds of things that can happen, but it's normally not extended out for years, right? It would be a short request, short time frame request for to extend it past that date. So.
Thank you for watching. Go to newsnationnow.com to find NewsNation on your television provider. And don't forget to click the red subscribe button below to get more of NewsNation's fact-driven, unbiased coverage.